deem it my privilege to introduce Shri Sudish sir. Sir is a senior advocate at the Karnataka High Court and an acclaimed author specialized in constitutional law and administrative law. Having obtained a master's in mathematics from Loyola College, Madras, and a degree in law from University Law College, Bangalore, with the highest marks in the university in constitutional law and administrative law, he started the general practice of law over 36 years ago. Sir assisted Dr. D.D. Pasu, the world-renowned commentator on constitutional law, in the revision of his commentary on the Constitution. He was also government advocate, High Court of Karnataka. He is a contributor to the Restatement of Indian Law on Legislative Privileges. He has been a visiting professor, Ashutosh Mukherjee Chair at the West Bengal National University of Juridical Sciences, Kolkata. He is also a resource person at NLU Bhopal for continuing legal education for judges. His contribution to academics, particularly in the area of critical constitution analysis, has been substantial and significant. I now request Sir to deliver his address on constitutional interpretation in India, some perspectives. Before that, I would also request Professor Shri to kindly welcome Sir with a bouquet.
Good afternoon, fellow students. I address all as fellow students in the fond hope that I am still a student. Today's topic, constitutional interpretation, reminds me of what Justice Frankfurter wrote in his Some Reflections on Reading of the Statutes. He said, though my business throughout my professional life has been with statutes, I come to you empty-handed. I have no answers. The answers to the problems of an art are in its exercise. Before I come to the topic as such, I think it's worthwhile to dwell upon for a moment and understand some fundamental concepts and their import. What interpretation is and why is it necessary? I think we will begin with the Constitution and constitutional law. The aspiration to make power impersonal and its exercise accountable has been the motivation for constitutions and constitutionalism. Constitutionalism is an attempt to establish the supremacy of law. Men throughout history have longed for a higher standard by which their own man-made laws are tested. Constitutions are that higher standard. The belief that individuals have natural rights, inherent and inalienable, which are anterior to any written instrument like a constitution. That government acquires its authority from the people. The purpose of government is to promote the common good. It is this what conceives and conceptualizes a constitution made in the name of the people, defining the parts of the main institutions and delineating the relationship between them and between the state and the citizens. Now, when we say constitution, we generally refer to a document like the Constitution of India, the Constitution of the United States, while constitutional law refers to the justiciable parts of the document. Courts, in interpreting the Constitution, try to discover the intention and thus enlarge and transform the words of the written Constitution. That's how a mass of constitutional law is built. Our Constitution, as we all know, is a country's supreme law. Lord Bryce defined it as a framework of political society organized through and by law, in which law has established permanent institutions with recognized functions and definite parts. The objectives of a constitution in a democracy may be said to be to establish the framework or structure of government, to delegate or assign powers to the various organs, and to restrain the exercise of powers so as to preserve individual rights. By defining competences and entrenching rights, the Constitution limits powers and protects liberties. It unfolds a vision and a goal and charts a nuanced path for their realization. The Constitution embodies and expresses the goals and aspirations of a people. It contains certain core political values and beliefs. There are limitations imposed by constitutional law on the actions of government, which are essential for the preservation of individual rights, notwithstanding the representative character of all political institutions. Now, it is in this background that we have to talk about constitutional interpretation. Now, anything written presents a problem of meaning. That's the essence of the business of construing any written document, which includes legislation and a constituent act like the Constitution. The problem stems from the very nature of language, and it is unavoidable. Draftsmanship is necessarily imperfect, as humans are imperfect. Words are symbols of meanings, but unlike mathematical symbols, the phrasing of a document rarely attains except approximate precision. Such is the character of human language, remarked Chief Justice Marshall in the famous case of McCulloch versus Maryland that Professor Ishwar Bhatt was referring to way back, I think, in 1819. And he said, such is the character of human language that no word conveys to the mind in all situations one single definite idea. A statute, and more so a constitution, is an instrument of government. You'll be interested to know that we have had more than 2,000 or perhaps 2,500 judgments of 5-judge and larger benches in India. That, I think, brings home the necessity and the importance of the subject of constitutional interpretation. Interpretations, as summoned, is a process by which courts seek to ascertain the intention of the legislature. But it is to be remembered that intention is not, the intention of the legislature is not the intention of any individual legislator. The legislature as a whole is taken as a unit, treated like an individual whose intention is to be ascertained from the language of the legislature. Technically, Cooley, the famous Thomas Cooley, in his classic work, Constitutional Limitations, points out that technically there is a difference between interpretation and construction. But I think we need not be bogged down by that, because these two terms are now used interchangeably. Laws are not abstract propositions. They are expressions of policies arising out of specific situations and addressed to attain particular ends. The concepts which laws embody are both explicit and immanent. Statutory language too has associations, echoes and overtones. Judges must retain the associations, hear the echoes and capture the overtones. These are the words of Justice Felix Frankfurt. A constitution, as we all know, is an enduring instrument providing for an expanding future. And therefore there is greater need and reason in giving its language a more liberal construction. Indeed, in the case of a constitution, strictly speaking, it is neither interpretation nor construction. As again Chief Justice Marshall said in the same case, McCulloch versus Maryland, we should never forget, these are the insightful words, we should never forget it's a constitution we are expounding. So we are not interpreting or constructing or construing, but expounding the constitution. It is exposition. A constitution, as he said, is framed for ages to come to respond to the needs of an expanding future and designed to approach immortality as nearly as human institutions can, and consequently to be adapted to the various crises of human affairs. These are the famous words of Chief Justice Marshall in McCulloch versus Maryland that Professor Ishwar Bhatt referred to in the morning session. A constitution does not work by itself or speak like an oracle. It is by judicial interpretation that you breathe life into the constitution. Now, constitutional interpretation or exposition is not an exercise in grammar or semantics. And we need to bear in mind it is also crucially different from construing a statute. I may place before you some of the thoughts of some very illustrious persons on what is constitutional interpretation or constitutional exposition. Dean Roscoe Pond said, "The principles established by the Constitution are not to be interpreted and applied strictly according to the literal meaning of the words. Further, constitutional provisions lay down great principles to be applied as starting points for legal and political reasoning in the progress of society. Interpretation of constitutional principles is a matter of reasoned application of rational precepts to conditions of time and space." Please mark the words application of rational precepts to conditions of time and space. So they don't remain static. In the words of Justice Higgins, uttered more than a century ago, words that have not withered or become sterile with years. He said, this is the Australian High Court. The High Court in Australia, you would remember, is the apex court. The state courts are called Supreme Courts. The highest court is the High Court of Australia. Although we are to interpret the words of the Constitution on the same principles of interpretation that we apply to ordinary law, these very principles of interpretation compel us to take into account the nature and scope of the act we are interpreting. To remember, it is a constitution, a mechanism under which laws are to be made, not a mere act which declares what the law is. And in UNR Rao versus Indira Gandhi in 1971, Chief Justice Shri, speaking for the Supreme Court, echoed the same sentiments when he said, "It must be remembered that we are interpreting a constitution, not an act of parliament. A constitution which established a parliamentary system of government with a cabinet." So this is important. Professor Ishwar Bhatt also referred to that, the form of government, the structure of the government, the structure of the constitution. A constitution established a parliamentary system of government with a cabinet. And in trying to understand, one may well keep in mind the conventions prevalent at the time the constitution was framed. So this is important. Constitutional conventions cannot be forgotten. The form of government, parliamentary or presidential, federal or unitary, are also significant criteria in understanding and expounding the provisions of the Constitution. Now, how does a Constitution speak? How do we get its messages? Is it merely reading the text and going by the simple letter of the law? Or is it something more profound? Is there a sound in the silences too? These are issues of great moment. Looking only to the text and the letter may give rise to cacophony. What is important is not only what the Constitution says, but also, and perhaps more, what it means and does. Sometimes even the silences are eloquent. What is not explicitly stated is eloquent and meaningful as what is stated. It is when speech and silence are juxtaposed, you hear a fleeting message which is the melody of the Constitution, if I may say so. Justice Douglas, in his Tagore Law lecture from Marshall to Mukherjee, said the judiciary must keep the charter of government current with the times, not allow it to become archaic or out of tune with the needs of the day. This is what we say in those famous words of Justice Holmes, the felt necessities of the time. The only problem is, as scholars have reminded us, felt necessities of the time is a beautiful concept, and it is all right in the hands of great judges, but with lesser men, with utmost respect, it may play havoc. Time works changes, brings into existence new conditions and purposes. In the application of the Constitution, our contemplation cannot be only on what has been, but of what may be. We cannot forget that constitutions at best work, apart from their express provisions, on the basis of practices and conventions that have evolved. And further, there is a moral dimension to every constitutional issue. The language of the text is not necessarily the controlling factor. Professor Lawrence Drive, who was referred to in the morning, in his very beautiful book, The Invisible Constitution, points out that constitutional silence pervades all of constitutional law. Invisible in the context means extra-textual. Constitutional silences, like silences of other kinds, are not occasional gaps or omissions. They are everywhere and come in as many flavors and varieties as sounds. The provisions of a constitution, said Justice Holmes, famously the famous case of Gompers versus United States, are not mathematical formulae having their essence in their form. Their significance is vital, not formal, to be gathered not simply by taking the words in a dictionary, but by considering their origin and the line of their growth. A constitution, he went on to say, is an experiment, as all life is an experiment. So it's all empirical. And his beautiful sentence in another case, I think this is what is so very elegant and which all of us remember. A word is not a crystal, transparent and clear. It's the skin of living thought and may vary greatly in color and content according to the circumstances and the time in which it is used. I think this underlines the whole concept of how a constitution needs to be expounded. Even a statute, but even more, a constitution. And Cardoso, in his classic Nature of Judicial Process, remarked, the great generalities of the Constitution have a content and a significance that vary from age to age. Professor Ishwar Bhatt referred to Justice Venkatajala's judgment in 94, in 93, in the Sikkim reservation case R.C. Pondyal. And this is what the learned Chief Justice said: in the interpretation of a constitutional document, words are but the framework of concepts, and concepts may change more than the words themselves. It is aptly said, the intention of a constitution is rather to outline principles than to engrave details. That's why, we can't be hidebound by words. In fact, if I may deviate for a moment, in the Supreme Court, I heard this when Mr. R.K. Garg was arguing some constitutional matter, and one of the judges was having a yellow book in his hand. As yellow was the cover of the Bare Act of the Constitution. He said, would your Lordship kindly put down that book? It's not yellow book that is required. What you need is vision. You're expounding a constitution, not the text. As Learned Hand told us, in matters of constitutional law, words that a judge must construe are empty vessels into which he can pour nearly anything at will. And in constitutional law, it cannot be confined merely to the words disregarding the gloss that life has written on them. The judicial function in interpreting a constitution, says Professor Archibald Cox, presents a paradox. The court must preserve its legitimacy and the ideal of the law by involving a majestic sense of continuity, building upon a continuity of principle found in the instrument, its structure and purposes. But it must also discover some composition with the dominant needs and aspirations of the present. Now the starting point, of course, is the text, the plain meaning. But the words in a constitution, however, may convey different meanings from words elsewhere. And that is why Marshall said it's a constitution which we are expounding. And Justice Holmes indicated the reach of that expression when he said in Missouri versus Holland, in language that remains so fresh and telling, when we are dealing with words that are also a constituent act like the Constitution of the United States, we must realize they have called into life a being, the development of which could not have been foreseen by the most gifted of its begetters. The case before us must therefore be decided in the light of our whole experience, not just what was said 100 years ago. The general rule, of course, is that a constitution must be construed as on the day after which it was enacted, but this is subject to qualifications. Dr. Wines, the great Australian authority, in his classic work, Legislative, Executive and Judicial Powers, speaks of generic interpretation. That is, while the power remains the same, its extent and ambit may grow with the progress of society. And Justice Venkatramaya, in the famous Gannon-Dunkerley case in 1958, spoke of flexible construction. He said, "It is not that the meaning of the words change, but the changing circumstances illustrate and illuminate the full import of that meaning. The question then would be not what the framers understood by those words, but whether those words are broad enough to include new situations and new facts." There are certain settled principles that guide courts in the matter of constitutional interpretation. All of you would be aware of them. The courts always start with the presumption of constitutionality of a statute. A mere doubt would not be a ground to declare a statute unconstitutional. In fact, it is said a doubt about its constitutionality must be resolved in favor of the constitutionality. But of course, the presumption is rebuttable and cannot be carried too far. That would make all liberties a mere rope of sand. You have the rule against extraterritoriality of legislation, which applies only to state laws, not to the union laws. So of course, there is in GVK Industries versus ITO about 10 years ago, there's a very passing confusion in the judgment of Justice Sudarshan Reddy speaking for a constitutional bench. Where he said that even union laws would suffer from extraterritoriality. Well, I very respectfully submit that union laws cannot be extraterritorial, and you can't strike them down on that ground. Maybe they can't be enforced. It may be foolish, but it's not for the courts to step in. That's entirely out of their purview. Harmonious construction, it's a well-known thing. Then you have the doctrine of pith and substance. You consider the real nature of the law, in which legislative list the legislation would really be. The power to make laws with respect to, these are the words in Article 256, they convey the doctrine of pith and substance. Now, incidental encroachment is inconsequential. Federal supremacy, Professor Ishwar Bhatt mentioned that in the morning. The opening words of Article 246(1), notwithstanding anything in clauses 2 and 3, very clearly bring in the concept of the union supremacy. Now, colorable legislation is another device. It is where the legislature indirectly, covertly transgresses the constitutional limitations. Of course, colorable, as Justice Krishna has said in his inimitable style, it has nothing to do with any malefides or anything, because malefides can never be attributed to a legislation. As Justice Chandrachud said, there is no such concept as transferred malice in the field of legislation. So, colorable again in the context simply means lack of legislative competence, power. It has no pejorative sense. Doctrine of repugnancy, you have a very illuminating, you have judgments down the line, but to refer to one of the latest, you have Forum of People's Collective Efforts versus State of West Bengal, 2021, 8 SCC 599. Justice Dhananjaya Chandrachud, a very exhaustive judgment on the doctrine of repugnancy. Now, the doctrine of occupied field is also the same concept. When there is a federal legislation, the federal legislation prevails. If the state legislation is repugnant to that, it can't prevail. And when you talk of occupied field, the question is whether the central legislation has occupied the whole field so as to preempt this provincial or the state legislature enacting a law. You also have the concept of reading down a statute. That is, you read it in such manner as would save its constitutionality. And closely related to that is the doctrine of severability, where if you can sever the unconstitutional parts, and if the rest of the statute would remain meaningfully, then you apply the doctrine of severability, save the constitutional parts, and strike down the unconstitutional. Doctrine of eclipse, of course, applies only to pre-constitutional laws, because post-constitutional laws are void from the time they are enacted if they conflict with Part 3. But pre-constitutional laws maybe, they say it's eclipsed, a shadow is cast by some fundamental right, and if that fundamental right is modified or there is some other amendment, that shadow may be removed, and that's the doctrine of eclipse. Now, the approaches to constitutional interpretation is either textualist or living constitutionalist. Textualists, you go by the plain words of the text. Then you also have the originalist or historical, that you go back to the time the Constitution was framed. Judge Robert Bach is one of the greatest exponents of this school of thinking. Doctrinally, you're bound by you follow the precedents. Structural, you look at the arrangement, the architecture of the whole instrument. And this is what we had in a very erudite presentation in the morning. Structuralism, structural interpretation. So if you look at the whole instrument and find out its meaning. Prudentialism is another is another tool. You reckon the social, political, and economic impacts, the cost and benefits involved. You're not unmindful of the consequences of the court decision on the country as a whole. Purpose, of course, is attributed to the former Chief Justice, the former President of the Israeli Supreme Court, Aaron Barrett, one of our very great jurists of recent times. The court has also invoked the doctrine of transformative constitutionalism, that is rooted in a transformative vision of the Constitution, transforming social and legal structures which perpetuate practices against constitutional vision. Now, in a very recent judgment, I think this is the Maratha reservation case, Shri Lakshman Rao Patil versus State of Maharashtra, 2021 8SCC page 1, a constitutional bench has neatly summarized the legal position. I would not quote from there. The sum and substance of it is that you follow step by step. You begin with the textual interpretation, because that is ultimately the bedrock on which everything has to be built. If there's ambiguity, then you go on to the next and so on. But you can't strain the language of the instrument beyond a point. What is important is that there is nothing hard and fast about any of these approaches, rules, or principles. They are different tools to be wisely employed individually or in combination of some or all. And that is judicial wisdom and statesmanship. One should bear in mind that the position of a judge in the Supreme Court, all are judges with great respect, but a judge in the Supreme Court is an entirely different responsibility. He needs to have vision. He can't be hidebound by the CPC and the CRPC. Even a good High Court judge need not necessarily make a good Supreme Court judge. A good Supreme Court judge is a material by itself. And that's why you had such great judges like Justice Krishnaiyer, who had an exposure to public life. Because constitutional law, of course he was very good in every other subject as well, but what I want to emphasize is its vision, not just the reading of the text and you don't interpret it like a contract. Judicial exegesis is unavoidable with reference to an organic act like the Constitution. It has to adjust in response to the felt necessities of the time and the practical needs of government and society, which cannot foresee today the developments of tomorrow in their nearly infinite variety. The interpretation or exposition cannot be frozen by the original understanding. It cannot be frozen in time. The Constitution evolves and must continue to do so, and courts must leave open the path for succeeding generations to meet the challenges unknown today. The criticism to such an approach is that it may lead to uncertainty and arbitrary exercise of judicial power. Because that criticism is not totally unfounded, and that is why I said you need vision and judicial statesmanship. But adaptability is not lack of discipline in judicial reasoning. It is still the Constitution which acquires the interpretative cues. No violence should be done to the text by rewriting it, Filling the gaps, construing the words or silences is one thing. Rewriting is very different. The former is permissible within acceptable limits. The latter would be wholly illegitimate. The court's fidelity to the Constitution secures its own subordination. Creativity and fidelity are not necessarily antagonistic. In fact, with devoted insight, they enhance each other. How to do it? Of course, that is a work of art. The silences in some areas are deliberate. They have to be sagaciously construed. Some silences are advisedly left as silences. Michael Foley, in his Silence of the Constitution, says, far from being a sign of decay, the presence of abeyances can denote the existence of an advanced constitutional culture. Silences are functional in a constitution. Lawrence Tribe speaks of door closing silences and door opening silences. Now, the law relating to privacy in American constitutional law is a typical example of door opening silences. Now, most of the provisions of the Constitution, particularly fundamental rights, have no fixed content. As Justice Hidayatullah told us, more freedom exists in the interpretation of a constitution because in the domain of constitutional law there is again and again a novelty of situation and approach. Now the Constitution does not say that, cannot and should not end an argument. And that's why I said you don't go by the letter of the law alone. Of course the text of the Constitution is important. We can't ignore it, but that is the beginning, not the end. I will tell you that the Constitution does not say that it's not a ground or reason to end an argument. And these ideas we have right from 1950 at the very beginning of the Constitution. You remember the cases of Ramesh Thapar and Brijbhushan. Freedom of the press is not explicitly provided for in Article 19(1)(a). It's only freedom of expression, but the court read that into 19(1)(a). One of the earliest cases, almost May 1950, you had the judgments. Then Article 12, state. The way the import of that expression has been expanded over the years, beginning with the Rajasthan Electricity Board case in 1967. Then Article 14, the right to equality. Original idea was reasonable classification, but we know how from Roypa it has developed that arbitrariness is the antithesis of equality. Now, life and liberty in 21 have been interpreted very widely. A large number of rights have been read into Article 21. A few years ago, the count was 25. I don't know how much it is today. The enunciation of the right to privacy is a telling example of the court employing different approaches and principles to amplify the content and import of our fundamental rights. Then again, the simple phrase, procedure established by law, has over a period of time been construed to mean that life and personal liberty cannot be deprived except by a procedure that is reasonable, fair, and just, and law is not any enacted apparition. The original idea that fundamental rights are watertight compartments is no longer the theory. The fundamental rights is not a series of isolated points, but a rational continuum of the legal concepts of liberty. 14, 19, and 21, the golden triangle that Chief Justice Chandrachud referred to in the Minerva Mills case. To begin with, as Professor Bhatt pointed out, the directive principles were considered and treated as subordinate to the fundamental rights. But after Keshwananda, for the last almost 50 years, social and economic rights embodied in Part 4, though not justiciable, have been, by a brilliant process of judicial exposition, harmonized and synthesized. Part 3 and Part 4 for the realization of the goals. And all these interpretations are classic examples of reading beyond the text, probing the subtext, and plumbing the silences. The Constitution speaks of the President in whom all executive power is vested. In fact, Blackstone said that in the context of the sovereign in England, and Dicey in his The Law of the Constitution commented that it has but one flaw, namely that the position is just the opposite. So too in India, when we say the executive power is vested with the President, in reality it is the Council of Ministers headed by the Prime Minister. I would beseech you, students of constitutional law, to read. You would have read, but if you have not, Samsher Singh versus State of Punjab, AR 1974, Supreme Court 2192, a 7-judge bench decision, particularly the concurring opinion of Justice Krishna. He poses the question, is the Rashtrapati Bhavan a halfway house between Buckingham Palace and the White House? And answers it picturesquely. Not the Potomac but the Thames fertilizes the flow of the Yamuna, if we were to use a riverine imagery. So that captures the essence of the parliamentary system of government. And in the CBI case, MP Police Establishment versus State of MP, 2004, 30 years later, the Supreme Court said that, reiterated the position, but recognized that there may be situations where an action may be compelled, which from its very nature is not amenable to ministerial advice. That is, when you have to prosecute a minister, how can the governor seek the minister's advice? And therefore, that is a situation where the governor or the president would have to act independent of the ministerial advice. Now, R.C. Pudyal I have also referred to, the second reservation case. Bomai's case, Article 356, how it was imbued, and Article 74.2, the decision of the cabinet is immune from judicial scrutiny. The court went on to say, well, the decision itself is immune. The material that formed the basis for that decision is open to judicial scrutiny, and if that material is such that upon that basis no reasonable person would come to a conclusion to recommend and impose President's rule, then the proclamation would be invalidated. So this is a watershed in the development of constitutional law and strengthening democracy and federalism. When we talk of constitutional interpretation or exposition, so we can't forget this, not just saying 356 said this, 74 said that, and you come to the result. No, the idea behind this is strengthening federalism and democracy. That development in Bomai was carried forward in Rameshwar Prasad, the Bihar case. Epur Sudhakar in 2006 is another instance where the court held that the pardon, the presidential and the governor's power to pardon is not immune from judicial review. The discretion has to be exercised on considerations of public good alone. The function of determining whether the act of the constitutional functionary falls within the constitutional conferment of power or is vitiated by self-denial is a matter for the court. Now, talking of silences again, you have the very brilliant case of B.P. Singhal versus the Union of India, governor's removal, 2010. The Constitution is silent as regards removal. Article 156 lays down the governor shall hold office during the pleasure of the president. But it was held. Withdrawal of pleasure and consequent removal cannot be for whimsical reasons, like the governor not being in sync with the policies of the union government or the ideology of the party in power. Thus, the doctrine of pleasure was read subject to the fundamentals of constitutionalism. Constitutional limitations were read into seemingly wide and unfettered powers. However, please mark this, the court in the same case, now this is as regards governors, in the same case the court said that in the case of removal of ministers or the Attorney General or the Advocate General, who also holds office during the pleasure of the President, the same words, such limitations would not apply, the pleasure doctrine would have its full scope. This is where I would say that in the same language of the Constitution, you have silences which open the door, you have silences which close the door. As regards governors, that is having regard to the structure of the whole thing, having regard to the position of a governor, the court held that removal of governors for reasons like not being in sync with the policies of the union government is impermissible. But as far as the ministry is concerned, we all know this is a parliamentary system, and you remain in the ministry only as long as the Prime Minister or the Chief Minister wants you. If you don't agree with the Prime Minister, your place is at home. You can't be in the ministry. And therefore, removal of the minister is totally permissible. He holds office during the pleasure of the President. The exact words would apply. This is having regard to the position of the governor vis-a-vis the minister. In law, context is everything, as Lord Shri told us in the famous case of Daly in 2002 appeal cases. So the constitutional provisions dealing with both are couched in the same language. The same silence permeates those provisions, but the exercise of construing and giving meaning to them is advisedly different. These are just a few illustrative milestone cases. Now, Article 111, 200, 201, question of assent to bills. It does not stipulate any framework, time frame, within which assent should be accorded. But how do you construe this silence? Of course, the court has not had occasion still, but I would say it has to be done within a reasonable time, because every action has to be reasonable, and reasonable would be within a reasonable time. And when can the governor really reserve? Is it just his whimsicality that he reserves a legislation for the president's assent? Consideration? The Constitution is silent on these aspects. But the question is, can the president or the governor stifle validly passed legislation by withholding or delaying assent? Convention has developed in all countries that the power of assent is never intended, designed, or exercised to defeat or undo legislation. And the convention in England is not since the reign of Queen Anne in 1701 has royal assent been refused. Equally, the other way around, the Constitution does not say about which house of Parliament a Prime Minister should belong, or whether you can be a Prime Minister without being in either house. Unfortunately, smaller benches, not constitution benches, in S.P. Anand's case and Janak Raj's case have held that you can be a Prime Minister for 6 months without being a member of either house. You can be a Prime Minister by being in the Rajya Sabha. I would very respectfully submit that this is totally wrong. This is construing the words of the Constitution in their plain sense. Forgetting the constitutional conventions, forgetting that we are a parliamentary form of government. The Prime Minister has to enjoy the confidence of the majority of the lower house. How can he enjoy it without his being a member of that house? A minister goes, nothing happens. If the Prime Minister dies or resigns, the whole government goes. The Prime Minister is paramount in the cabinet, and therefore this interpretation with utmost respect calls for a reason. As the Supreme Court has told us, the silences of the Constitution must be imbued with substantive content by infusing them with a meaning which enhances the rule of law. Constitutional interpretation should be such as would promote constitutionalism and inculcate a constitutional culture. It is also important that in interpreting the Constitution, the court strikes a balance between idealism and pragmatism to make it workable. Professor Ishwar Bhatt told us in the morning, and of course we can have no two opinions about that, that perhaps the greatest example of construing the Constitution and exploring and voicing the meaning beyond the text is Keshwananda. There's no doubt about that. But the thing is, ultimately, in construing the sounds of the Constitution speech and giving meaning to the silences, It is an act of judicial wisdom which calls for a measure of statesmanship. It is what Aaron Barak called balancing between different interests, different values. There is one other very important principle which I would like to refer to, and that is what is known as the democratic dialogue. The relation between institutions, particularly the legislature and the executive, is more political, and in one sense, constitutional adjudication is and must be a dynamic interaction between the wings of government, a democratic dialogue. You have scholars writing on it. Courts remind the legislature of the values that might otherwise be neglected, and legislatures respond by expanding or refining the terms of the debate. Professor Dieter Grimm, a former justice of the Federal Constitutional Court of Germany, has spoken about it. But more importantly, I would like to draw your attention to what the Supreme Court, speaking to Justice Jalnay Chandrachud, said in 2021. The same idea is echoed. Gujarat Ujjwal Vikas Nigam versus Amit Gupta, 2021, 7 SCC 209. The core of constitutional dialogue is that the different wings, judiciary and legislature, engage in a conversation about constitutional meaning in which both actors should listen to one another, their perspectives, which can lead to modifying their own views. The court at its heart is an institution which responds to concrete cases. It is through the instrumentality of an interinstitutional dialogue that the doctrine of separation of powers can be operationalized in a nuanced fashion. And it is in this way the court can tread the middle path between abdication and usurpation. A very profound idea. Having said all this, just another 4 minutes, I would like to enter a caveat. In the process of interpretation and deciding matters, judges make law, but then only interstitially. Law is molded and sometimes changed by the process, but this is subject to legislative oversight in the sense that the law can be changed. However, today it is not uncommon for the court to exercise full-fledged legislative and executive power, travel into realms not belonging to it. In this process of legislating, issuing directions touching matters of law and policy, constitutional limitations are breached. Legislative and executive actions are tested and corrected by the judiciary. But judicial action, which partakes of both legislative and executive character, leaves one aghast. To whom do you turn for remedy? If the salt has lost its savour, as the Bible says, wherewith can it be salted? The Keshwananda doctrine represents a high watermark of judicial innovation. But the point is, after that, the court has been inventing constitutional limitation from supposed basic features, the list expanding according to the whim of each judge who takes a fancy to open the Pandora's box. The concept being imprecise, undefined, and unchannelized, many a time it means nothing more than erecting a judge's individual prejudices and predilections into constitutional principles. When you talk of basic structure, it is always to be what was basic in the Constitution, not what the judges developed and put a gloss over the years. The typical case is the judge's case. In the second judge's and third judge's case, the judges rewrote the Constitution, not interpreted it. And to crown it all, in the fourth judge's case, they took that as the basic structure. And put it on the ground of independence of the judiciary, very fashionable. We can't forget what Sir Aladi said in the Constituent Assembly. The doctrine of independence of the judiciary is not to be raised to the level of a dogma, so as to enable the judiciary to function as a kind of a super legislature or a super executive. And Justice Krishna in the Sankalp Chand case said, avoiding callous underestimations and morbid exaggeration, we must realize that independence of the judiciary is vital, but is only an inset to the larger picture of the nation's free and forward march. There are many situations like this, one could go on and on, but these are some telling illustrations which I am afraid eat into the vitals of our constitutional structure. And we have to necessarily, wisely, advisedly avoid. Talking of interpretation, and let me just quote 2 or 3 and then I will conclude. Chief Justice used, because we are all very happy, very fashionable to quote this. The Constitution is what the judges say it is. This is what Chief Justice Hughes said in 1910, much before his elevation to the court. But please remember what he said as a judge, as the Chief Justice in 1936 in Carter versus Carter, Cole and Company. He said it's not the function of the court to amend the Constitution by judicial decisions. And in Graves versus New York, Justice Frankfurter, in the concurring opinion with which all the other judges agreed, said in 1939, the ultimate touchstone of the constitutionality is the Constitution itself, not what we have said about it. Equally profound is what Justice Blatt said. Public welfare demands that constitutional cases must be decided according to the terms of the Constitution, not according to the judge's views of fairness, reasonableness, and justice. I have no fear of constitutional amendments properly adopted, but I do fear the rewriting of the Constitution by judges under the guise of interpretation. And these words were echoed by Justice Bhagwati in the first judge's case, when he said, judges bending the language of the Constitution to their will would be rewriting it in the guise of interpretation. But unfortunately, this has happened in many cases, and we cannot forget that Justice Krishna Iyer wanted judges to solemnly remind themselves of what Charles Warren, the historian of the US Supreme Court, said. However the court interprets the provisions of the Constitution, it is still the Constitution which is the law. In saying all this, the idea is only to seek improvement. If the Supreme Court is to be the guardian of our liberties and of a correct interpretation of the Constitution and the laws, the unpleasant, painful, but inescapable duty of pointing out errors falls on academic and practicing lawyers. Professor Gladwell Williams' question, quis custodiet ipsos custodis, who watches the watchman, was answered by Professor Ataya in his brilliant 1987 Hamlin lectures on pragmatism and theory in English law by saying the answer clearly was Professor Gladwell Williams, or in default, some other academic lawyer of equal caliber. One is fortified by what Justice Holmes said. I take it for granted that no hearer of mine will misinterpret what I have to say as a language of cynicism. I trust no one will understand me to be speaking with disrespect because I criticize the law so freely. I venerate the law and our system as one of the vastest products of the human mind. But one may criticize even what one reveres. Law is the business to which my life is devoted, and I should show less than devotion if I do not do what in me lies to improve it. And he spoke of the isolated secret joy of the thinker, who knows that 100 years after he is dead and gone, men who have never heard of him will be moving to the measure of his thought. It is in this spirit of humility and inquiry that I have placed some thoughts before you. Thank you so much for your patient hearing.